Thank you. Sorry about that. Next call. The next item is roll call.
Kevin Bright,
Here.
That one yours?
Brian,
I think so, yeah.
Bob, Pamela Mishler,
Here.
Barbara Ignatz,
Here.
Greg Stipp,
Present.
Luther Williams, Nikki Witkowski,
Here.
Rick Byrne.
Here.
6 present, you have a quorum.
Thank you. Next items are approval of minutes for January 24th and May 22nd, 2000.
To approve.
Second.
Okay, we have a motion and a second. All those in favor, say aye.
Aye.
Those opposed, say nay.
He broke it.
Minutes are approved.
Oh, what the hell I did.
Okay, any new correspondence at this time?
No.
No correspondence? Okay.
Mr. Chairman, who made
What do you
the second?
And Nikki
Nikki.
was second.
Nikki made
Oh.
Yeah.
Kevin, you seconded.
Kevin made the motion. I
And-
seconded.
Thank you.
Sorry, I'm fixing our iPads.
Okay. Case Z0-2024-8, applicant is John Morgan, care of Adam McAlpine with McAlpine Consultants LLC. Project is U-Lock Storage Development, location 691 West US Highway 30, Valparaiso in Union Township. Zonings are R, Rural Residential District. Request rezone a partial of land to I-1 Institutional District for the proposed U-Lock Storage Development.
Good evening.
Okay,
I'm not Adam.
all right, well,
Go ahead.
before you start, Michael, you want to introduce yourself? Okay, go ahead.
I'm not Adam, as I said. My name is Chuck Parkinson. I'm an attorney. My address is 107 Broadway, Chesterton. I'm here with John and Gail Morgavan, who are the petitioners, and Adam McAlpine is here. He's the project engineer. As you noted, this is a zoning change request.
Okay, well, thank you.
maybe a little background history. Petitioner did appear before the Development Review Committee on August 7th. Originally, petitioner wanted to, what I get from the presentation, was to change zoning of the entire lot to I-1 upon discovering that commercial zoning had a front to be changed at I-1 would not be able to do auto sales without these variances. So subsequent to that, petitioner changed his request to zone I-1 on his property. Well, there's two parcels. The commercial part is split parcel to the west. That parcel will remain zoned commercial. We went back through the records and dug out, and we did find an error, by the way, which will correct. And this petition was changed so the remnant of the parent parcel will be zoned I-1 for that purpose. We've reminded the petitioner now that when he comes up to do what he has to do, that he does the development phase, will have to adhere not only to the I-1, but to the Ontario route overlay, roadway overlay does have some higher standards that they have to be taken care of during the development process. So again, we did find some errors in the zoning map. We will make those corrections with
Okay, thank you.
There goes an hour of my presentation. So as noted, I'm here on behalf of John and Gail Morgavan. They own property which is located in Union Township. Just to make everyone aware, the agenda indicates that this is property at 691 West US Highway 30. The petition says that it's property northeast of 698. It's actually, the legal description is correct in what was sent out, what was published, but the property is actually located northeast of 685 US Highway 30. So, just to be clear, the 691 property is owned by Farm on 30 LLC. This is property that's owned by John and Gail Morgavan, and the correct address is northeast of 685.
Okay, sir, let me stop you there. I have to talk to council. Is that an issue with notification?
I'll look at the notification in a moment, but I believe what I heard was the actual legal description of the property was correct. And I would check, assuming that the neighbors that were notified surrounding would have been on this parcel and not the incorrect parcel.
Sir, thank you.
That's what was on the application for the record. We did what
Okay.
was on the application.
Okay, thank you.
Yeah, I just wanted to make everybody clear of that.
Yeah.
Because I know that there were some neighbors who approached the owner of 691 and said, "What are you looking to do here?"
Okay.
That's happens to be John's sister.
Okay.
So, what we're asking you to do is forward this petition with a favorable recommendation to the Board of Commissioners for a rezone from the current zoning of RR to an I1 zone. And that would permit John and Gail to put self-storage facilities on the property. And again, they're not looking to rezone the 5 acres, which is in the southwest corner of this parcel. That has already been zoned CM a long time ago, probably 40 years or more. And over the years, John has operated a car lot there. And that's still the intention to do that. Over the last couple years, there's been a laydown yard there related to some NIPSCO power line improvements. But right now, this 34-acre parcel is basically farm ground. So the property, again, located on West US Highway 30 out in Union Township, approximately 1 mile east of the county line. They own not only this particular piece of ground, but John and Gail also own the 40 acres immediately east. And that is predominantly wet toward the north, also used as farm ground. The property to the north of this is farmed, and in fact, John rents out the subject parcel to the same owner of the farm ground to the north. So again, we're not looking to rezone this particular 5-acre parcel in the southwest. That will remain a CM zoning. That particular parcel, just so you get an idea of the neighborhood, and an adjoining 5-acre parcel to the west, which is owned by John's sister, is also a commercial zoned property. Those two 5-acre parcels back in the 80s were rezoned commercial. John's sister operates, or she rents out that particular property to a commercial operation. So again, this particular area that's not a part of the petition is already used for commercial purposes, has been historically for decades. Across the southern part of the subject parcel and extending northeast, you will find some high tension power lines. They cut right across the southeast corner of the property that we're looking to rezone. They also cut across the bottom third of John's adjoining 40 acres. So the plan here is to construct some self-storage units. This would be constructed in the on the north side of the commercially zoned property, so to be tucked back in there. We are subject to the arterial roadway overlay district here, so we do have some setbacks that we need to follow in terms of US 30. So, for example, we can't build any structures closer than 400 feet to US 30, so we will comply with those setbacks. There will be a frontage drive that will be created, which will cross over the existing. In fact, if you're out there, you'll see that there is a drive that crosses across the car lot. That would extend into the subject parcel, and then it would move north toward the storage units. Not only would the setbacks apply here, but the architectural standards would apply along with the landscaping requirements. So this particular parcel would be well suited to that, because if you could move the development up toward the north, it's a large enough parcel that we can get the landscaping done, the shielding in, and set this back far enough away from the road so that it really wouldn't be that visible. According to the overlay district zoning, there is no outdoor storage that's allowed. So this would all be indoors. If there were any outdoor storage contemplated, that would have to come back for a variance at a later date. But right now, the plan is everything would be indoors. So a more detailed review of the specific plans would be done after the zoning change is obtained. And at that time, the plans will come back. If there is plans, for example, to have an office there with a restroom, there'll need to be a plan for septic. There'll need to be plans shown in terms of the water supply. I believe there is Indiana American Water, but it is on the south side of 30. So there'll need to be some plans shown to the satisfaction of staff that we've got a water supply there. To access this particular lot, there is a driveway that is shared by John's sister's property at 691 and the existing lot at 685. And there is an easement of record that permits John and his lessees to utilize that easement, that access easement. And again, that would be something that an access road would be created, which would then connect to a driveway up to the units themselves. Importantly, you should know that there is a decel lane on the north side of US 30 already, so that traffic coming in from the east has a decel lane to get into that shared drive. And that shared drive also is immediately across from an access from the west. So there's an access. We have to determine whether that's limited or in what sense it is, but there is access to the west. So that traffic coming in from the west can use that access, go to the drive, and then use the easement to go back to the units. So with any development plan, we would be working with the staff to address the signage. Right now, there is an existing freestanding sign that's on the commercially zoned part of this. But if there's additional signage that's necessary for the units themselves, that would have to meet, of course, with the arterial roadway overlay standards. So this was the subject of the DRC. I think that was August 8th. I was not there, but I did watch the meeting on YouTube, and I know that there were some concerns raised by staff. The one was concerning the existing use of the commercially zoned property and whether that was going to continue. Understand that at the time, the petition contained all 40 acres of the property. The petition's been amended to cut out that 5-acre commercially zoned property so that that existing use can remain. And the only thing that you're considering this evening is a rezoning of the other 35 acres. There was also concern about signage on the property. Again, once we come in with a plan, we'll address what signage is appropriate for the overlay. There were concerns that there were maybe some semis or something out there that had signage on them. Those have been removed. I went out to the property last night to take a look. I didn't see any of those particular semis out there. And so, again, all those things can be conditions as part of the development process and whatever plan we bring to you at that time. There was also an issue concerning the septic, which might be necessary if there's an office. And again, that's something that if there is an office that is placed on the property, there is certainly significant area back there for a field. And again, if there's water supply that's necessary for the office, it'll come from Indiana American. And I think the only other concern that I heard from the Development Review Committee was concerning the outdoor storage. And again, the plan is to comply with the overlay, which does not permit outdoor storage. So for you to consider the rezone, the UDO states that you should zone property I-1 only after determining that the site's appropriate for the use. And here, it's really a site that's not conducive to a residential use. It's simply on a busy highway. The access points are just simply not available. And with the high tension wires that travel through the south, I believe that's not a selling point for residential development. So I think that this is an appropriate use for the zone. It's not entirely out of character with the area. And we would ask you for a favorable recommendation. You, of course, could place some conditions or ask for some commitments here. In looking through the permitted uses in an I-1, there are certainly some uses that are permitted in I-1, which John and Gail have no interest in seeing out there. I think there's no interest in anything that would really bring a lot of high traffic. And if you think about self-storage units, they do not generate a significant amount of traffic relative to residential subdivision. Similarly, I think they would commit not to have industrial wholesale, for example, office structures, print shops, and similarly, they wouldn't want anything that generates a lot of noise, dust, so no assembly, no distribution facilities, and so forth. So with that, we'd look forward to answering any questions you have, but would ask you to forward a favorable recommendation to the Board of Commissioners.
Okay, well, thank you.
Mr. President, so on the notice issue, we did take a look. So we did not have this problem. It was properly noted. Second of all, I think, and staff correct me if I'm wrong, but I think the route to overlay being not being set properly. It's 100-foot building setback off of 30, not 400. The overlay is only the first 400. Okay, so I just want everyone to understand the overlay, whatever restrictions are within the overlay, does not apply to the entire parcel. It applies to the first 400 feet. Building line's 100. Just for clarification.
Well, thank you.
Mr. Attorney, that's a scenic road overlay part of the ordinance.
Arterial.
It's the arterial.
Arterial, okay.
All right, thank you. It's a public hearing. Mike, you want to read the rules of conduct, please?
Certainly. Conduct of hearings at a public hearing before the commission, petitioner and proponents shall first present the facts and arguments in support of the case. Those who oppose the petitioner shall follow. Petitioner shall have the rebuttal. It shall be within the discretion of the commission to oppose any time limitation either the petitioner or the respondent, and to limit public comment to those determined by state statute to be interested parties. Written remonstrances shall be accepted by the commission, but need not be read into the record. This then concludes the public hearing. To maintain orderly procedure, each side shall proceed without interruption by the other. In presentation of the case, the burden shall be upon the petitioner to apply the information necessary for a clear understanding of the problem. The commission may continue the hearing when in its judgment the petitioner has not provided sufficient evidence on which to make a determination. Every person appearing before the commission shall abide by the order and direction of the president. Discourteous, disorderly, or contemptuous conduct shall be regarded as a breach of the privileges of the committee and shall be dealt with as the commission directs.
Thank you. Okay, anybody want to speak in favor of this case? In favor? We had one person sign in. Nancy, Coughlin. Are you speaking in favor or against? Okay, sure. Come up, Nancy. Microphone. State your name and address, please.
Nancy Coughlin, 691 West US Highway 30. So I'm the person that, I'm at the address that it was sent out, that everybody thought I was the one to some petition. I just want to make sure that, I guess, I'm not sure how it's listed, but I guess all those parcels were listed under 691, which are not in fact 691. So I hope that they will correct that down in the future so that people don't confuse me with those parcels.
Okay.
My question, or some of my concern, would be the access road is on my property, and would there be like 24-hour access to this U-Haul or storage area? Because I live on the property, and I would be seeing people coming and going all night long if that were the case. Also, I have to maintain the road. So, my concern would be there has been a lot of traffic on that road in order to put the utility lines up. And so there was a lot of heavy traffic that has already deteriorated that road as it is. So the portion that's on my property, I have to maintain.
Okay.
So those are my concerns.
Okay. Thank you. Anybody else want to speak in favor? Seeing none. Anybody want to speak against or have any questions? Seeing none, I'm going to turn back over to attorney.
Just with respect to the easement, I have a copy of the easement here. It's been recorded. It's a public record, and of course, it's silent as to the maintenance. And under common law, if John and Gail have been granted easement rights, they've got the obligation to maintain it. So, with respect to the maintenance of this particular road, and if you would be interested in seeing a little bit more assurance that that would be maintained, obviously we can enter into an agreement with his sister on that, but they do have an obligation to maintain it. Currently, there's no restrictions similar, in the easement with respect to access. So, John or his customers on the lot, car lot, can access this at any time. Again, this is a very limited use in terms of the amount of truck or the amount of traffic that would be coming in. I don't know the average trips per day, but it's relatively low in terms of what I've seen, the studies on how much trip generation there is. But again, with respect to the use of that particular property, right now he's got an easement. There are no restrictions like that. He does have the obligation to maintain it.
She also asked about 24-hour operation.
Well, it's possible. More than likely, if there were, there would be limited access to anybody who's renting back there. It wouldn't be like the general public would be coming in 24 hours a day. It would just be whoever's got a right to access their unit.
Well, I think that's what she was asking.
Yeah.
Okay.
Right.
Okay. Nancy, any other questions? Did he answer your question? Okay.
Is there any possibility that they could get another access to their property too, Highway 30, so that this wouldn't affect my property as much?
We're going to be discussing that.
Mr. President, can we have it for our sakes pointed out which ones she's referring to as well? We're getting confused at listening to her. We're getting confused which ones we're talking about.
Okay.
All right.
So that's what I'm saying. Yeah, if you can point, that's the driveway we're talking about right there, or is it the one on the other side?
The woman that's speaking is this property.
Yeah.
Okay.
John Morderman is this parcel and this parcel. I believe this parcel.
Correct.
Yeah.
And to give context to you, I was going to wait, but Kevin and I talked about this. Back in the early 80s, NDOT bought limited access right-of-way rights across the frontage. And I'm assuming back in 1980s, driveway was permitted here. If you were to get that, maybe you can address to that, Chuck. But you would have to go with NDOT to break that limited access rights they bought. Is it impossible? No. But I assume this was set up and a frontage road back at the time, which was allowed. It's not allowed today, but this frontage road was put in because they all shared this access point.
Mhm.
And I assume this was done before the land was subdivided.
Correct.
So when this, and this were all together, this is the drive to the property. It's since been subdivided. Am I telling the chronology right, Mr. Morgan?
Yes.
So that's the background
Okay.
for you.
So is that a driveway on the far right too, or no?
This is temporary because NIPSCO was
Temporary.
working along the
Okay, so that's gonna go away. So then the only one on the far left is the only drive,
That is correct.
only access. Okay, thank you for that
Michael,
clarification.
one clarification so everybody understand. That's not service road. That's a private drive.
That is correct.
Okay.
It was called a frontage road back
Up front.
then. We do not allow along
So-
areas today. But since this is already there,
Okay. And that's where her question
future
coming from.
development that we control over there'll be no
Okay.
frontage road. They have to go.
Okay. You're concerned because of traffic, of course. You live there. Okay. Okay. So we understand. Thank you. Okay, anybody else have any questions? No? You want to respond to that?
Just point. I know she does live there. She's also got a business there too in the front. I mean, certainly there's going to be a little bit of increased traffic. This would certainly be limited to those people who have a right to be in there, but you know, I think it should be understood that there's already commercial traffic going in and out of there to her business. So,
Okay. Thank you. I'm going to close the public hearing. Bring it to the board. Kevin?
Well, part of my concern is the size of the parcel itself. To rezone 35 acres seems excessive at this point. And the second thing is some of the uses, in my opinion, should be eliminated from the I-1 district because, among other things, they include sexually oriented businesses, which I don't think we want on the gate to Valparaiso, but that's just my recommendation. There are several other things that, or businesses that could possibly be put in with I-1. And as I brought up at DRC, one of the things we just want to be aware of is people setting up shop in warehouses. In other words, running businesses out of the warehouses, which really isn't very advantageous to the owner either. There's a lot of additional liability. But those are really my biggest concern. I think is just rezoning 35 acres is one big chunk. I would suggest maybe look at a plan for a smaller parcel and then win the confidence of the county if that proves successful for additional warehouse storage.
Okay. Thank you, Kevin. Nikki?
He hit a lot of it, and to me, again, it's that if there's a way to firm up the usage, the driveways, and clarifications, I'm not saying we have to go all the way to NDOT, but that's something that makes me nervous is going forward. What else, especially again, if we're allowing that I-1 on the whole district, which I'm not saying I'm massively opposed to, but whatever else could come in under that in the back portion of what you had on the map, that's where I'd start wondering, how quickly is that road going to degrade?
Okay. Thank you. Mr. Sims?
Yeah, my big thing is the agreement that would have to be about fixing the road because I can easily see well, we didn't do it. No, we didn't do it. Well, who did it? There's a big hole in my property right now, and who's going to fix that? That's I've seen a lot of fights happen because of a small tree limb falling on a fence. And I know this sounds kind of petty, but I'm sitting there going, God, that was. I get mad if something happens in front of my property. Going, now I got to deal with that hole, and is the county going to fix it? And I don't know. But I don't want to ramble. But that's if you guys can solve that, then that would make me even happier. But or easier for me to give a thumbs up to it, just to stop any potential future issues, especially if somebody new moves in down the road. You know, just got to protect people's property. That's all, and be good neighbors.
Okay, thank you. Nikki, have a
Well,
question?
sorry. Yeah, it made me think of a question though on this. The road is something we can resolve later, correct? Because tonight is about the zoning, correct? Meaning, we can solve the issues with the road another time, or does it have to be tied with this zone? I don't know if I'm talking
As
to you.
council, I think it has to be tied together.
What you mean by
Yeah.
Meaning, if we say that we want some sort of a covenant on the road better done, or we say, well, no, we want you to apply to NDOT to get your own access because we don't like this shared usage thing. Is that something that has to be done now with the zoning to go as a covenant, or can it be done later?
well, if you're like piece apart the in-depth part to keep with just the rezone and the covenants, you could do a recommendation on the zoning, favorable or unfavorable, with the condition that there's a road agreement worked out for the ingress and egress and a maintenance agreement. Once you start getting past that and into INDOT, then you're into a completely different set of water.
Okay.
And if your vote, if anyone's vote is contingent upon another road cut in INDOT, then that is not something I would recommend you approve.
But that's what you said, if nothing else, is what I needed to hear is if we want a contingency on that road, it should be stated tonight.
Correct.
And how you phrased it, I couldn't repeat it. But that's what I needed to hear after thinking that, because I always sometimes forget sometimes we have to separate out, is this a zone issue or a later issue? So sorry about that.
No, you're fine. Pam?
I agree with Kevin. That is a lot of property to be rezoned. I live in Union Township, and I know that area is notorious for sand pits that eventually turn into somewhat dump situations. And I'm very concerned about the property maybe initially being used for storage and then the back acreage being used for a whole different purpose. Um, I'm definitely concerned about that. And then the second thing is about the driveway. I don't know if I would want to live next door to a facility where there are people coming in, not necessarily all day and all night, but if somebody wanted to get something out of their storage facility and it was midnight, I'm assuming they wouldn't be prohibited from doing that. Um, I don't know what type of business that owner has, if she has, if it's 24-hour business or if it's just Monday through Friday, 9 to 5. I don't know what kind of business she has, but I would be concerned about that. If I lived there, I'd be concerned about people coming in and out whenever they wanted to.
Thank you. Commissioner?
I do have a question. Mike, can you show me where the actual driveway is on the petitioner's property and where it projected to move it north?
And just one more, or zoom out. So they're planning, if I'm reading it right, they want to put their operation buildings up here, correct? Right up here. This is zone commercial, it's gonna stay the same. This, all the way up to the property will be I-1. The only access to this property is here through this frontage road.
But where is the driveway going to go to the?
I think according to the plan, it kind of comes through here and doesn't circumnavigate and then go into the property. It attaches
It
port.
it is on here. I was gonna say
On there.
Yeah.
if you, it's like on
Yeah.
one of the, I don't know, one of the later pages. Page 8.
There. North is that way. See, the road is here. They're gonna go north, over, and up.
Oh yeah, I see.
So, so somebody that has, they're renting a storage unit, they come in here
Mhm.
and they come here and then they go here?
You can, it depends on your overlay. If your overlay says it's gotta be 100 feet of grass, then we'll go through the commercial part to get to the I-1. If it doesn't, then we'll come straight across.
The way I understood it, come all the way here.
Yeah, come, exactly.
Okay. So then actually, they're not gonna be close to her house.
No.
If you take it straight across like this, so all she's going to see is cars going right here.
In and then they'll turn east.
And that,
Over here.
Then they'll go east. When they reach the parcel, they'll go north,
and if you also,
They're not cutting here. They're
which
going
is
all the way over here.
Right.
and where you're showing that where you're asking whether they're cutting, that's John's property.
Yeah.
They'll only go onto Miss
What is
Coughlin's.
this? Like, is this her house right here?
No,
That's her business
to the west.
location.
Her house is over here.
It's in the back.
No, it's right there.
Is it right there?
No, come back,
Her house is
Oh,
right
there
there.
it is.
right here.
Yep.
It's her house. So if they're coming here, they're not really getting that close to her house.
closer to the business.
I'm more concerned about the repair to the road.
The other question I have is how many storage units? So how many potential customers will you have?
Right now, the plan would be for 300 units, 10 by 20, so approximately 60,000 square feet.
And how much acreage does that take up?
Adam?
3 and 4, and then add access drives to that.
How many?
Three to four for the development.
Okay.
Rooftops and circulation drives.
But how many acres is that? 3 to 4?
It'd be 3 to 4 of the subject property.
Okay.
Right.
And what about lighting and everything? Is that
Lighting.
We'll have it'll be 24-hour security
right?
and cameras.
But will Nancy be able to see those lights? I mean, is
I
that
don't think so because there's a lot of, I mean, we're talking the very north edge there where it would start. So she's probably at least 1,000 feet away.
okay?
Regardless, we have a nuisance ordinance, so we need to make sure the commissioner's right. We need to protect all neighbors from fugitive light. So
We actually have light power too.
right, we need to protect them from your lights from the car lot. Maybe it's time to remedy that.
So, why did you petition to rezone all 35 acres when?
It's going to be in different phases. The first 300 units can go up within probably 60 days.
Okay.
They're rented out within, say, 6 months completely. We'll do phase 2 and phase 3 and keep going back.
Okay.
Then we want to do a controlled environment storage where it's controlled temperature too.
Okay.
Council, does the petitioner own the parcel east of the highlighted?
Yes. Yes. There's
The
40 acres.
What's the access to that 40 acres?
There's really,
it's a field entrance right through it.
yeah, there is a field entrance.
Is there an actual NDOT cut for that 40?
No.
Yeah.
Well, there's that temporary cut that NIPSCO did.
But beyond that you're cut.
There a cut off there?
That isn't a temporary. That was put in there by NDOT. There's culverts underneath that.
That's on your property,
That's on the property to the east of that.
but it's his property to the
It is
east
his
of the
property.
correct?
Yes.
All right. And that's permanent?
It has been. It's been there for 40 years.
No.
They have culverts underneath it.
In NDOT part.
No, the NDOT cut.
Yes, that little section to the east of right there, that has culverts put in through by NDOT. Put those culverts in as a field entrance, a permanent field entrance.
That's what I'm saying. NDOT parlance, that's called a farm field entrance.
Oh,
Mhm.
yeah.
If you
It's not necessarily a road cut though.
No.
Correct.
no, but the limited access right can be void through there. And so real estate records, NDOT would require you to upgrade that beyond farm field if you're interested in beyond that. So there may be a cut in the limited access right away. I can't say that. We'll have to do that due diligence.
And the reason why I bring it up is because we have the same owner and the same access problem. It's not just the property that has access off of the relative's property. For everyone to
It's got to accept. Commissioner, any other questions?
No.
No. Well, my concern is the growth. I mean, you could have 1,000, 1,500 units when there are more, and plus they're going to have temperature control units. Now you're talking businesses, trucks, box trucks, so on, coming in for records and storage. Just, I can't see how that, I call it a private drive service road is going to work. That kind of value. I meant your plans to expand, and we have seen in the county several storage facilities they expand, and that's part of the business. And I can see this expanding, and where I'd like to see a private, your private cut, own cut for the property. But that's what I like to see. But like you're saying, Scott, that other cut, could they apply for that? He owns the same owner. I know where you're coming from. It's a good.
Mr. Jabel has a good point.
Yeah.
In my limited experience in those transactions, there's not normally a what's the parlance farm and field entrance on top of a impossible to get a that's been bought, and now it could have been in that document as part of that negotiation. But I mean, obviously, if he either has a real cut or can get a real cut, that obviously helps him tremendously.
Yes, absolutely.
And is only good for him, and probably helps develop this area a little bit more traditional.
Yeah.
But you only know that until petitioner consults with them.
Back to Kevin. Kevin, opinion?
Pardon?
Opinion on a highway cut?
It's because it's limited access. There's a problem of negotiation on how much time it's going to take, and even then, you'll need engineering. That'll be several $1,000s at least, because you'll need some decel XL lanes out of this thing. And one of the problems State Highway, in my opinion, will have is there's not a crossover right across from this. The crossover is across from your sister's entrance there. Yeah. And if you do something with your sister, I strongly suggest having a written agreement that's binding for the maintenance and the width and the other things to go along with it, because with the traveling on that road now, you probably need to do some structural improvements on it, because I can visualize this as originally being just a gravel driveway, that eventually people start putting more stuff on it.
If I can I, if you don't mind,
Yes.
Mr. President,
No.
can I just address that? I mean, we have these, this was negotiated when the property was basically split between the siblings. With respect to the size of the parcel, understand that if you zoned the southern half, say 17 acres, I-1, and left the remainder RR, that RR would never be developed. It would never be developed residentially. And it couldn't be developed in an I-1 fashion. I mean, there are any number of uses on here that are not important and are not uses that he would want to see here. We can go down the list. You don't operate an office out of there. You don't operate a sexually oriented business. You don't operate anything that generates noise, etc. But to say that you're going to kind of cut that parcel in half and only develop the south because you're concerned about what might happen on the north, what definitely will happen on the north is it'll be rendered useless. And that's the concern I think he has, and that's why the petition was submitted for the 35 acres. And I agree that maybe something more detailed ought to be worked out in terms of the access. I believe that the easement is sufficient. I mean, there's no limitation on in this document to who he can assign this to. It says that he's the grantee, their successors assigns lessees. He can assign this easement to anybody he wants to right now.
We get that there's no debate
Right.
there. The question is who's going to pay or what compels somebody to participate in the maintenance of the driveway.
Understood.
For the effectiveness of your facility. Also, I differ with you as far as useless ground. This is agricultural ground, and we're taking it out of production, which I appreciate. Mr. Morgan owns this, and he can plead his case in front of us for developing, but still, I wouldn't say that's useless. But on the other hand, I don't see a complete plan here, a follow through. And I think our concern as planners, at least mine historically, has been, okay, what happens next with this property? You only put up so many units, and then we still have a commercially zoned area up here with a myriad of possibilities.
Nikki? Any
I don't have anything further.
That's for Pam.
Nothing further at this time.
Nothing further.
Yeah, I have to go with Kevin. I'm concerned about the future growth. I can see your master plan. I'm concerned about, I'm going to call it driveway. Is that driveway sufficient, to carry all that traffic in the future? I know you're starting with 300 units, but I can see many, many more. So we need some type of agreement. Who's going to maintain that roadway? How's it going to be maintained? I'm sorry, the public hearing's closed. I'm sorry. Do we have a motion or anything else?
What we have in front of me, I'll make a motion to deny. I just,
Is it deny or is it unfavorable?
I'll make an unfavorable recommendation. I'm sorry. Sorry, Madam Commissioner.
Yeah.
Well, and I'm confirming for myself, it's not a denial, it's an unfavorable
It's an
recommendation.
unfavorable recommendation too.
Do we have a second?
I'll second that.
Okay. Okay, we have a motion and second to deny. It's just available.
And bear in mind, we're just making a recommendation to the commissioners. They have the final say. So even if we recommend it, they could deny.
So yes means no.
Yes, no. Sorry.
Those are always hard.
You made the motion.
I did not make the motion. Wait, you. Just saying yes means no hurts my brain.
All set. You're a Hoosier. The nurse. Just saying. Oh, I like it.
Too tired to hear you. Just don't. Started out as hard as November, and it's actually.
Oh. Well, tell me if that's thing too.
It's okay. I'll do this for today.
In the case of docket number Z02020
It's gone.
to give unfavorable recommendation to commissioners, 5 yeses.
Okay, thank you. Motion carried.
Thank you.
Okay, thank you.
Thank you.
When is that hearing? Do we have a date?
Commissioners had a meeting yesterday, maybe 3 weeks from yesterday.
Okay, about 3 weeks.
3 weeks after.
We don't have a definite date.
We have definitely.
Yeah, let's give a definite date. If we have it, let's give a definite date.
I think it's the 17th.
next commissioners meeting is September 17th.
Okay, thank you.
All right, thank you.
Okay, any other items to discuss? Nothing? Do we have a motion to adjourn?
So moved.
Yes, okay. Motion second?
Yeah, really good.
We're ready.
All in favor? Adjourn?
Aye.
Hi.
Opposed?
I
Meeting's adjourned.
Get to stay late.
I got nowhere I really have to be right now.
Study for your EMT.
I know. September 10th.
Yeah.
Didn't you bring up some program to tell Benson about Stop the Bleed?
No. Why would I do that? I don't like Bill Benson. Yes, I did. I'm doing one.